Good evening to everyone. So, based upon the requests that I received from some of you, and the last effort of me to try and find out from you some of the things that you wanted us to actually discuss. Chieftaincy was one of them. So I thought that we should spend some few minutes trying to discuss at least some of the basic aspects of chieftaincy law, insofar as it's relevant to constitutional law, and for that matter, the exams that you will be doing. So I think that if for nothing at all, you should pay attention to the whole of the chapter 23 of the Constitution, and you should also pay attention to the Chieftaincy Act. It's not really a lengthy act, so I think that it's something that you can easily manage. And the issues that I think we will have to pay attention to, we need to first understand the legal foundation of chieftaincy in Ghana. Then we need to be able to define who a chief is according to the Constitution. And then you need to also know how a person is considered disqualified from assuming the position of a chief. And then we also need to know the National House of Chiefs, and we should also know Regional House of Chiefs, their composition and their functions. And then we should also know what we call the cause or matter affecting chieftains in terms of jurisdiction, right, over chieftaincy matters, and the relationship between the judicial committees of the House of Chiefs and the courts. Yes, somebody's hand is already up. Yes, what is it? God?
The chapter of the Constitution. I think it's chapter 22, sir. Doc.
Oh, right. Okay.
Yes.
Right. Thank you. Yeah,
Okay, Doc.
yeah, it's 2022. Yeah, so that's a mistake. All right, thank you. So look at chapter 22 or articles 270 to 27. Yeah, so I think once we know this, we should be fine. I have sent the act. I have the act here. I'll be sending the act to you so that just in case you don't have it. And if you look at it, the act is made up of just 26, right? So in terms of sessions, not many, there's about 77 sessions, and not all of them are really, you can quickly run your eyes through them, and I think that you should be fine. So just a few points I'd like to highlight, and then you look at the Constitution chapter 22, and as I said, the Chieftaincy Act itself. So to start with, we have to remember that when it comes to the institution of chieftaincy, I said that we need to understand the legal foundation. And for this, I want to draw your attention to the fact that the chieftaincy as an institution, right, its existence is not as a result of the Constitution. The existence of chieftaincy as an institution is traceable to customary law and usage. So what the Constitution is doing is just guaranteeing or recognizing that which exists already. So it's not the Constitution which is creating the institution of chieftaincy. The institution of chieftaincy is older than the Constitution and the constitutional arrangement. So let us keep that in mind. And this is very important for us to appreciate when we look at the historical backdrop. If you remember, during the colonial time and also the independence president Nkrumah's time, where chiefs virtually had to be given recognition before they could even be treated as a chief, as it were. That is part of the reason why the framers of the Constitution, in their wisdom, have stated that if we are talking about chieftaincy, as Article 271 says, that the institution of chieftaincy, together with this traditional council, as established by customary law and usage, is hereby guaranteed. So the Constitution is very recognizing that which exists already. So let's keep that in mind. And that is why, despite the fact that Parliament has legislative power, the framers of the Constitution, in their wisdom, have actually deprived Parliament of certain matters in respect of which it can legislate. And that is why Article 70, Clause 2 is quite clear that Parliament shall have no power to enact any law which A, confers on any person or authority the right to accord or withdraw recognition to or from a chief for any purpose whatsoever. And this provision, as I indicated, is historical. We have had a time in our history during which chiefs had to be given recognition by the government of the day and so on. But later on, we got to appreciate that that is quite wrong. Chieftaincy is something which is very much part of our culture. And the way that it exists should not depend upon the whims and caprices of whoever who's governmental authority before a chief can have the proper recognition. So that is the proper understanding of Article 272A. And again, Parliament is also denied the power to make a law which in any way detracts or derogates from the honor and dignity of the institution of chieftaincy. All these things are reinforcing the point I have made that the institution of chieftaincy predates the Constitution, and that is why it's not the Constitution which is recognizing it. The Constitution is only saying that yes, this institution is there, and we confirm that it's there. The Constitution is not establishing, it's only guaranteeing, it's only giving assurance or confirming that which is already there. And that is why the legislative power of Parliament has been circumscribed so that it will not be used to make certain laws which will undermine the institution of chieftaincy. So that is something for us to actually keep in mind all the time. And again, when it comes to even making determination as to like where a traditional council has made a certain decision, right? Or regional house of chiefs or national house of chiefs have made a decision concerning whether someone has been validly nominated as a chief, or elected as a chief, or selected as a chief, or installed as a chief, or even as whether someone has properly been deposed as a chief. These are matters which lie properly within the jurisdiction of the houses of chiefs. And that is why Parliament has been prevented or deprived of the legislative power to legislate on those matters. So Parliament, for example, cannot make a law and says that you need to do X, Y, Z before we consider your nomination, election, or installation, or instrument, or whatever as valid, or even your deposition. These are matters which have been established by customary law and usage, and that is one thing that we have to keep in mind. Now, what I would like to actually draw your attention to is the fact that in understanding who a chief is, that is Article 277, which has also been reinforced by the Chieftaincy Act. The Chieftaincy Act also reinforces, if you look at the section 57 of the Act, just want to show you the exact position. And so if you look at the section 57 of the Chieftaincy Act. It's just reenact what we have in Article 77 of the Constitution. So, who is a chief in Ghana? So, according to Section 57 of the Chieftaincy Act 2008, and also according to Article 277 of the Constitution, a chief is a person hailing from the appropriate family and lineage, has been validly elected or selected and installed and skinned or installed as a chief or queen mother in accordance with the relevant customary law usage. So please pay attention to the wording. The same statement could be repeated, and then they can drop in accordance with relevant customary law and usage. Now, without that, we have not properly defined who a chief is, because we cannot explain as whether a person hails from appropriate family or lineage, or a person has been properly been nominated or elected or selected or skinned or installed as a chief without having recourse to the relevant customary law and usage. And that is very important. And also for your multiple choice and all that, you have to remember the particular wording over there. And we also talk about disqualification, right? Now, if you look at the Constitution talks about a person who is disqualified as a chief. And especially if you look at Article 275, right? Article 275 of the Constitution tells us about who is disqualified as a chief. And Article 275 is what has been reenacted in the Section 57 of the Chieftaincy Act, that a person does not qualify as a chief if that person has been convicted of high treason and treason, high crime, or of an offense involving security of the state, fraud, dishonesty, or moral turpitude. So we have to also pay attention to the grounds of disqualification of a chief, so that if we need to probably answer any question, we'll be able to tell. So once you have ever been convicted of any of these offenses, high treason, high crime, an offense involving security of the state, fraud, dishonesty, or moral, then you cannot be a chief. So let us keep that in mind. And also you should remember that having been arrested and detained in police cell per se does not disqualify you as a chief, because in that case, you'll not be convicted. It is when you are convicted of any of those offenses before you will be disqualified, and not just mere arrest or detention. So let us keep that in mind. And another point we have to remember in trying to define or understand the office of a chief is that a chief is prevented from taking part in active party politics. And if you wish to take part in active party politics, or if you are seeking election to parliament, then the Constitution requires, and the Chieftaincy Act also requires, that you abdicate your stool or skin. Now, during the Constitutional Review Commission work in 2010, and I've sent the Constitutional Review Committee report to you, you can just go to the small session on chieftaincy, and you become familiar with some of the issues which came up, for which people would like us to reform the law. So, for example, there was a strong view that we need to, of course, it was an equally balanced view. Once you of course says that let's maintain the provision of the Constitution, right? let's maintain the provision of the Constitution, that Article 276, which says that a chief shall not take part in active politics. Not active politics, active party politics. Some said that we should retain it because chiefs are unifier. They bring people together and all that. And another school of thought said that no, there are some chiefs who are very good and their services will benefit the state if they were allowed to take part in active party politics, but they don't need to lose the stool or the skin that they occupy. So amend the constitutional provision so that they can still take part in active party politics. Now, what I would like to suggest to you is that for purposes of examination, especially the essay, right, for the essay part, I'm not saying there'll be a question, but it's my duty to be a teacher, to be raising possible questions. There could be a question, right, which is inviting you to actually discuss whether chief should, whether we should amend the constitution to allow chiefs to take part in active politics. And this is a question which will actually require that you are supposed to do a debate. You have to be familiar with the arguments which are out there. So depending, if the question is not asking you to take a position, but to look at both sides as it may be, you have to know arguments justifying the current position. And if you look at the Committee of Experts report, right, Committee of Experts report, and you look at the debates in the Consultative Assembly or the Constituent Assembly, which actually deliberated on the proposals by the Committee of Experts leading to adoption of the 1992 Constitution. I mean, the key arguments made to justify this particular provision that chiefs should not take part in active party politics is that chiefs are seen as symbols of unity in their various communities. And they're also the embodiment of our culture, right? Embodiment of our culture and all that. And that being the case, they should not be allowed to take part in active politics, which will necessarily require that they will have to take a biased stance, or they will have to have their judgment clouded by the particular party that they are standing for, and so on and so forth. And that is why the framers of the Constitution in their wisdom actually provided for Article 276 that chiefs are not to take part in active party politics. And then you also come back to the other arguments that that we should allow chiefs to take part in active party politics. Well, those who actually support that position, or among other things, says that if we look at the contemporary developments, things have changed, and we have a lot of very good, knowledgeable, competent, highly skilled people who can impact on politics very well. And for that matter, the fact that they have been nominated, selected, installed, or installed as a chief should not deprive the state of the services of such highly meritorious individual in active party politics. So we need to rethink it. And some also say that we are living in some kind of like the, we are deceiving, ourselves, in the sense that in reality, a lot of chiefs actually partake in politics and politicking along even active party politics line, except that they cannot even run for office, but some use their platforms actually to make bold utterances or even openly declare their support for candidates and all that. And if that is so, why shouldn't we regularize it and rather be deceiving ourselves that chiefs should not be allowed to take part in active party politics. So we cannot exhaust the arguments, but I've just said this to actually guide you in how you should think about the issues. But I will recommend strongly that if you are interested in chieftaincy, and assuming there's going to be like any question in terms like the composition part of your exams, then it will not be out of order if you quickly run your eyes through the relevant portion of the Constitutional Review Commission report on chieftaincy, so that you get yourself acquainted with some of the things which are there. Okay, so that is one thing you have to pay attention to. Then the other thing I am interested in is that if for nothing at all, we have to remember what we call the National House of Chiefs. The National House of Chiefs, we have to know like the composition, and we have to know the functions. And as I said, anything is possible. So once you are working hard, you cannot take anything for granted, but you never know. So if you look at section 1 of the Chieftaincy Act, if you look at the section 1 of the Chieftaincy Act at 759, it reenacts what is already in Article 271 of the Constitution. Because if you look at Article 271 of the Constitution, Clause 1 provides that there shall be a National House of Chiefs. Now, how is the National House of Chiefs actually constituted? How is it composed? The National House of Chiefs consists of 5 paramount chiefs from each region, elected by the regional House of Chiefs. Regional House of Chiefs of that region, right? So 5 paramount chiefs. But if it should happen that in a particular region, the paramount chiefs are less than 5, then they can add divisional chiefs. They can elect some of the divisional chiefs to add to the number of the paramount chiefs who are there, so that we get a 5 to represent that region at the National House of Chiefs. So let's keep that in mind. And the paramount chiefs who meet at the National House of Chiefs, they will have to elect one of their members to be the president of the National House of Chiefs. So remember that it's not the president of Ghana who will choose the president of the National House of Chiefs, and it's not Parliament that will choose it. It is the chiefs themselves that will choose one of their, and they will choose their vice as well. And quite, we follow the democratic principles in electing the members of the National House of Chiefs, and the Electoral Commission facilitate that. So with respect to the term of office, is just the term of the executive and the legislature, that is 4 years. So every 4 years, the elections will be conducted for the president, the vice president, and then a member who has finished serving 4-year term, but the person is eligible for re-election. The only caveat being that if you are the president, and if you look at this, if you are the president, you cannot serve as a president for more than 2 terms. The historical explanation for this is not in the Constitution, this is in the Chieftaincy Act. And the reason for it is that when the National House of Chiefs started, the then Ukukwal II, the Asante, he was for a long time, if he had to go to the National House of Chiefs and for if he wanted to stand, he will be re-elected since he has so many paramount chiefs from different regions. And that was eventually seen to be not fair. So he even decided not to take part in that. And when they did the Chieftaincy Act, they put a limit there that you cannot become president or vice president of the National House of Chiefs for more than 2 terms in succession, meaning that if you do 2 terms in succession, you have to allow some breathing space before you come back again, as it were. And you don't also qualify to be the president or the vice president. if you are disqualified as a chief, as we have seen, that is convicted of high treason, high crime, offense involving fraud, dishonesty, or moral turpitude. Or if you are judged to be of an unsound mind, or you've been insolvent or bankrupt in any law anywhere in the world, then you are not qualified to be a president or vice president of the National House of Chiefs. And again, if you also have a professional qualification and you are disqualified from your profession, so that let's say if you're a lawyer, you are debarred from being a lawyer, or you're a medical doctor, your licenses are revoked and all that, then you also don't qualify to be elected as a president or vice president of the National House of Chiefs, as it were. So please just keep that in mind. And then let's also be abreast of the functions of the National House of Chiefs. According to the Constitution, we look at the Article 272 of the Constitution. It calls out 4 main functions, and these functions have been reenacted by Section 3 of the Chieftaincy Act, that the National House of Chiefs basically are supposed to advise any person or authority who has to do anything relating to chiefs or a cause or matter affecting chieftaincy. And I like the second function, and I would like you to think about it well. Now the National House of Chiefs, right? They have been given the mandate to undertake the progressive study, interpretation, codification of the customary law, with a view to evolving in appropriate cases a unified system of rules of customary law, and compiling customary laws and lines of succession applicable to issue or sin. So the idea, right, or the view or the vision of the framers of the Constitution is that over time, the National House of Chiefs will have actually helped in generating for Ghana a codified, a well-coherently written out principles of customary law, as well as the lines of succession to various rules and sins in the country, so that things are organized. So that is one of the functions of the National House of Chiefs. And again, if you remember the Cause Act, okay, let me take you back to the Cause Act. When, and there's a question from a Ghana legal system, I think that we have talked about before, that is when we are talking about judicial ascertainment of existence of customary law. Because if you look at Article 11 of the Constitution, it talks about the common law of Ghana. The common law of Ghana also includes customary law. Now, the customary law, we know, is a question of law, not a question of facts. And then the principle in Angu versus Atta has been abolished, because Angu versus Atta said that customary law is a question of fact and not a question of law. That is no longer the law. The Constitution says that it's a question of law. And what that means is that when an allegation is made that a certain rule of customary law is, it is the responsibility of the judge to ascertain whether it actually exists or not. And the judge is giving some guidelines. If you look at the Cause Act, I think section 54, 55, it says thereabout. If you look at the Cause Act, the judge may have to follow some steps in trying to investigate whether a particular, an alleged rule of a particular customary law is true or not. And among other things, he could even contact the National House of Chiefs or the Regional House of Chiefs in that particular area. And if you remember the case of Ebila in Salifu, what the judge did in that respect. So that was just by the way. And then if you look at the C, the National House of Chiefs, they also have a duty to undertake an evaluation of traditional custom and usage with a view to eliminating custom and usage that is outmoded and socially harmful. And those of you who are interested in the homosexuality question, right? When you are making your argument, especially if you are trying to make an argument, let's say that against the legalization of same-sex marriage or something like that. And you want to argue that, if you want to argue what you call the cultural argument that culturally marriage is between opposite sex and all that, and that is the culture. And you can make the point that the framers of the Constitution even anticipated that if a certain cultural practice, for example, has become outmoded or has become socially harmful, it is the National House of Chiefs which is supposed to engage in an evaluation, right? Assess and demonstrate that this particular cultural practice is no longer useful and is socially harmful. And then you make the argument that not until the National House of Chiefs, and for that matter, chiefs have actually done evaluation of marriage between a man and a woman, which has traditionally been the way that we understand marriage. We cannot say that heterosexual marriage has, for example, become outmoded, or we should necessarily modify it to also accommodate same-sex marriage. I'm just trying to say this just to tease your mind in terms of how creative you can be in making such an argument. Yeah, so these are the functions which the National House of Chiefs is supposed to perform. And of course, Parliament can also make a referral to it, right? So like this so-called the promotion of the proper human sexual rights legislation, Parliament can make reference to the National House of Chiefs so that they will have to study it and advise as to whether it is a law which they think is good or anything like that, as the case may be. And that is consistent with the kind of functions the Constitution contemplates for the National House of Chiefs, as it were. So let's keep that in mind. I mean, the rest are just the details about their meetings. That is not really important for purposes of you preparing for your exams. So knowing the functions, I think that is enough. And then let's talk about the Regional House of Chiefs. Now we know the National House of Chiefs. We have to know about the Regional House of Chiefs. And again, if you look at the Constitution, especially Article 274, it also contemplates that we shall have Regional House of Chiefs. And of course, without Regional House of Chiefs, we cannot have National House of Chiefs, because we've seen that the National House of Chiefs is made up of 5 paramount chiefs from each region, or where a region does not have up to 5 paramount chiefs, then whatever paramount chief they have plus the complementary number of divisional chiefs from that region, they actually feed into the National House of Chiefs to get the National House of Chiefs. So it goes without saying that we have Regional House of Chiefs. And how is the Regional House of Chiefs actually constituted? Now, if we look at the Constitution, it says that each region shall have Regional House of Chiefs. So now we have 16 regions. And what it means is that we're supposed to have 16 Regional Houses of Chiefs. Now, who are the members of Regional House of Chiefs? If you look at the Constitution, 2742, it says that a Regional House of Chiefs shall consist of such members as Parliament may by law determine. And Parliament by law, that is the Chieftaincy Act, Act 759, have determined per section 6 that in accordance with Article 74 of the Constitution, the Regional House of Chiefs consists of members specified by legislative instrument made by the National House of Chiefs and issued under the signature of the President of the National House of Chiefs. So what it means is that the membership of Regional House of Chiefs is actually determined by the National House of Chiefs through the means of ally or legislative instrument. It's not Parliament who will determine the member and all that. So Parliament chiefs within the region, if you look at the law, ally, are represented on the regional House of Chiefs. So you have to be like a paramount chief, except where in a unique situation, you don't have enough paramount chiefs, and then divisional chiefs are allowed to be represented as it were. So I think that is what we, and they too, they elect their own president and vice president. Now, what are the functions of the regional House of Chiefs? Now, in terms of their geographical jurisdiction, it's just within the, and a regional House of Chiefs is supposed to advise any, just like the National House of Chiefs. They are supposed to do, if you like, almost all the things that the National House of Chiefs, does, except that theirs is limited to the region, whereas the National House of Chiefs is the entire country. So that's the only difference. So if anybody has to do anything concerning chiefs and all that, it is the regional House of Chiefs who have to advise the person so far as it affects chieftaincy in the region. And they're also supposed to undertake a study and make general recommendations that are appropriate for the resolution of the disposition of chieftaincy disputes in the region. So they also carry out studies into problems affecting chieftaincy, which has generated into dispute. And the studies assist in resolution of those chieftaincy disputes. And these are the matters that we have to keep in mind. And of course, just like the National House of Chiefs, they're also supposed to be the region. They are supposed to compile customary laws and lines of succession applicable to issue or scheme in the region. And they can also be asked to do any which may be assigned to it by any act of parliament or other enactment as well. So these are some of the things that we need to pay attention to as far as the chieftaincy is concerned. I mean, the rest are just the meetings, right? Now, apart from the regional House of Chiefs, we also have the traditional council. And the traditional council is, we have what we call like traditional area, and the traditional area usually under the control of a paramount chief. So the paramountcy, that is like the traditional area. That way maybe you don't have like a paramountcy and then you have like a division, and then it's a matter. And they're supposed to have what they call the National Register of Chiefs, right? So if you are a chief within a traditional council, your name is supposed to be stated in the National House of Chiefs, and the National Register of Chiefs, which is a special register established by the Chieftaincy Act, so that to be able to know who is a chief and who is not a chief. Otherwise, anybody at all can buy umbrella or buy some smoke and get few people to follow him. He's a chief. So those are some of the. Now, in terms of the traditional council, the paramount chief of the area is the automatic president, right? So if you have like a paramount chief in the area, automatically he is the president of the traditional council. The only exception is that when you go to Kumasi traditional area, Asantehene is the president of the traditional council, because the Kumasi traditional area, the dynamics are a bit different from the normal traditional area as it were. Then the other things we have to be aware of is what we call like the divisional chief. Yes, Emmanuel Zaika. Emmanuel.
Yeah, Doc.
Yes.
Yeah, Doc. And that's what I wanted to find out is the O2 for what's is he a paramount chief?
Okay, all
And
right.
does it belong to the National House of Chiefs?
Okay. Otumfuo is a paramount chief sui generis of a special kind, in the sense that he if you tell like the Kumasi as a paramount, but that is not the proper concept. But he's a paramount chief, but has also got other paramount chiefs under him. Now, he's not a member of the National House of Chiefs, but he's the automatic president of the regional House of Chiefs in the Ashanti region, except that he may allow the Mampong chief, who is the second in command, or if you like the Drabin chief or something like that, to actually perform some of his functions for him. Yeah, so that is. Emmanuel, is your hand still up, or was the previous one? Okay, so let's come back to something which is really important. Now, so maybe just to sum up, so in terms of that structure, we have the National House of Chiefs, followed by the Regional House of Chiefs, followed by the Traditional Council, followed by the Divisional Council, right? So that is the hierarchy. National House of Chiefs, Regional House of Chiefs, Traditional Council, and then Divisional Council. That is what it is. Phyllis, Akoria. Phyllis, yes? Phyllis, your hand is up. I've asked you to unmute. Phyllis, are you there? Okay, maybe it put his hand up accidentally. Okay. Yeah, so the other thing I'm interested in is what they call the chieftaincy matters, jurisdiction and judicial committees. Phyllis, yeah, I asked you to unmute, but I didn't unmute. Yeah, Phyllis.
Hello.
Yes. Yes.
Yeah, I was having some challenges with my net. That is why I'm sorry about that.
Okay.
I just want to make a follow-up question with the gentleman who asked about the capacity of Asantehene as far as the Regional House of Chiefs is concerned.
Okay.
And if I got you correct, then he's an automatic president of the Regional House of Chiefs. And if he's not there, he delegates to Mampohene.
Maybe let me add that it's not automatic as stated in the law, but in practice.
Good.
The reason being that it's election, and assuming the Asantehene wanted to contest for the president of the Regional House of Chiefs in Kumasi or Ashanti region, no paramount chief would dare even dream that he also put himself up for election. It's like you will be challenging your overlord, isn't it? Yes.
Yeah, that is okay. Okay. On that score, I wouldn't like to make any follow up again.
Okay.
I'm so grateful.
Okay. Yeah. So the other point, which is very important for us as law students, especially at this level, is what we call the jurisdictional matters when it comes to chieftaincy issues. And let's pay attention. So we are starting from the National House of Chiefs. The National House of Chiefs has got original jurisdiction in cause or matters affecting chieftaincy in certain situations. And pay attention. The National House of Chiefs is, their judicial committee is supposed to be an appellate body. However, it has original jurisdiction in cause or matters affecting chieftains in 3 limited instances or 3 limited situations. So you should know all the 3 properly. First, where a matter lies within the competence of 2 or more regional house, meaning that if there's a cause or matter affecting chieftaincy, and we have 2 or more regional house of chiefs which can deal with that, then the National House of Chiefs can also deal with it in its original jurisdiction. So that let's say that if there's a matter, the Ashanti Regional House of Chiefs can deal with it, the Bono Regional House of Chiefs can deal with it, the Ahafo Regional House of Chiefs can deal with it. Then that same matter can be taken up by the National House of Chiefs because the matter is not unique to a particular region. So that is 1. 2, it has original jurisdiction in the cause of matter affecting chieftaincy, which is not properly within the jurisdiction of a regional house of chiefs. So if there's a cause of matter affecting chieftaincy, which does not come properly within jurisdiction of a regional house of chiefs, it can be taken up by the National House of Chiefs in its original jurisdiction. And thirdly, it has original jurisdiction in the cause of matter affecting chieftaincy, which cannot be dealt with by a regional house. It's not the case that the regional house does not have the jurisdiction. It has a jurisdiction, but for whatever reason, right, it cannot be dealt with by the regional house. And this may happen in a number of situations. Either the Judicial Committee is not properly constituted, they don't have the full complement of members, or the legal advisor they're supposed to have, or whatever. And certain matters come up. Because the regional house is not well constituted to be able to deal with that, which it has jurisdiction, the National House of Chiefs will be able to take up that matter. Now, quite apart from that, the National House of Chiefs, as I said, has got appellate jurisdiction. And it has appellate jurisdiction in a cause or matter affecting chieftains, which will be determined by a regional house. So if you go to Judicial Committee of the Regional House of Chiefs and you are aggrieved, your next level of appeal is not the High Court, it's not the Court of Appeal, it's not the Supreme Court. You rather go to the Judicial Committee of the National House of Chiefs. So that is what we should keep in mind. But where the National House of Chiefs, per its Judicial Committee, has presided over a matter in its appellate jurisdiction, and you are aggrieved, you are dissatisfied, and you want to appeal again, then you go straight to the Supreme Court. So from the National House of Chiefs, you don't go to the Court of Appeal, you don't go to the High Court, you go straight to the Supreme Court to appeal against the National House of Chiefs decision. So as it were, as far as the appellate jurisdiction of the National House of Chiefs is more or less analogous or at the coordinates, like, status for the Court of Appeal, because the appeal is a judgment of a Court of Appeal which is appealed to the Supreme Court. And again, the judgment of the National House of Chiefs in its appellate jurisdiction goes to the Supreme Court. And that one, let's also pay attention. Where you are appealing to the Supreme Court, right, from a decision given by the National House of Chiefs in its original jurisdiction, you appeal to the Supreme Court as of right. As of right means that you don't need permission from the National House of Chiefs. Neither do you need permission from the Supreme Court before you can appeal against a decision decided by the National House of Chiefs. Just as if the Court of Appeal had decided a matter and you want to appeal, you appeal straight to the Supreme Court and you don't need leave and so on. But where the Supreme Court, where the National House of Chiefs are, for example, presided over a matter in its appellate jurisdiction, meaning that it started probably from the Traditional Council, it came to the Regional House of Chiefs, and the National House of Chiefs. The National House of Chiefs has presided over it in its appellate jurisdiction. If you want to appeal to the Supreme Court, you need leave of the National House of Chiefs or leave of the Supreme Court. So you go to the National House of Chiefs and make a case for leave, for permission to be given so that we can appeal to the Supreme Court. Or you go to the Supreme Court for leave or permission to appeal against a decision made by the National House of Chiefs in its appellate jurisdiction. Now, where the National House of Chiefs exercises original jurisdiction and you need to appeal to the Supreme Court, it lies automatically as of right. You don't need leave. So let's take note of that. Yeah, so I've mentioned the Judicial Committee of the National House of Chiefs, and the Judicial Committee of the National House of Chiefs, they exercise the original and the appellate jurisdiction that I'm talking about. And how is the committee constituted? When the Judicial Committee of the National House of Chiefs is exercising the original jurisdiction of the National House of Chiefs, it comprises 3 members, right? But then when it is sitting in its appellate capacity, it comprises 5. So original 3, appellate 5. Jacob.
Yes, Doc. Good evening.
Good evening.
Doc, you said if you are seeking leave from the National House of Chiefs to appeal to the Supreme Court, are you going as to the Supreme Court and review, or I just appeal?
Okay. I said 2 things: that the National House of Chiefs, they decide some cases in their original jurisdiction. That is when the cases have arisen for the first time. It has not gone to any original House of Chiefs or any other forum. Now, where the National House of Chiefs has presided over that case in its original jurisdiction, if a person is aggrieved by the decision and you want to appeal, you appeal straight away to Supreme Court, and the appeal lies as of right. You don't need permission of the National House of Chiefs or the permission of the Supreme Court before you can go to the Supreme Court and appeal against decision of the National House of Chiefs made in its original jurisdiction. On the other hand, where a matter, for example, has traveled from the original House of Chiefs to the National House of Chiefs in the appellate jurisdiction or appellate capacity of the National House of Chiefs, if you are dissatisfied with that decision, then you appeal. You need, and you want to appeal to the Supreme Court, you need leave of either the National House of Chiefs or the Supreme Court itself. So you can apply for the leave at the National House of Chiefs, or if it is refused, you go to the Supreme Court and repeat it, or you can straight away go to the Supreme Court and ask for the leave to appeal against the decision given by the National House of Chiefs in its appellate jurisdiction. Jacob, are you clear on that? Okay, I think Jacob, are you clear on that?
Yes, Doc, I'm good. Thank you very much, Doc.
Yeah, so I think that these are the matters that we actually need to pay attention to. The rest are not really important to you at this stage because we haven't done the civil procedure. Then let me talk about supervisory jurisdiction of the High Court in relation to chieftaincy matters. So before I even say that, from the discussion done so far, you will appreciate that the High Courts, Court of Appeal, and Supreme Court, they don't have original jurisdiction in any matter or cause affecting chieftaincy in Ghana. However, the High Court has supervisory jurisdiction over an adjudicating body established by under this act, meaning that if the regional House of Chiefs have, for example, made certain errors and you want to get a judicial review, right? You can invoke the supervisory jurisdiction of the High Court, and then you can get certiorari to pass it or prohibition, quo warranto, or mandamus. In the same vein, you can also have supervisory jurisdiction over the National House of Chiefs, as it were. But in terms of like the appeal, right? In terms of appeal, decision of the National House of Chiefs will lie to the Supreme Court. The High Court does not have appellate jurisdiction over even the Regional House of Chiefs. It is only supervisory. Supervisory simply means that where maybe we have a breach of a natural justice or certain procedural errors which affects the proper exercise of jurisdiction by the Regional House of Chiefs, whatever, then the High Court will intervene in its supervisory jurisdiction. So that is what you should keep in mind. Rami Kofi, you can unmute yourself. Rami, you can unmute yourself. Oh, sorry. Just allowing them. I'd rather put your hand down. Yeah.
Hello, Doc. So thank you very much. We have looked at the definition of, yes, we have looked at the definition of a chief. Hello?
Yes, I'm here. I'm here.
Yes, so what I'm saying is that we have looked at the definition of a chief. We've looked at the definition. We've looked at the definition of a
Then your line is not good, so another time. Yeah, just before I leave, let me share a few thoughts with you concerning customary law. And if you look at the Chieftaincy Act, it has a very useful provisions on customary law. And I think that since customary law is important, let us briefly look at that. So if you look at the section 49 of Act 759, that's the Chieftaincy Act of 2008, you notice that the National House of Chiefs has been given the power, subject to Article 11, Clause 2, to undertake progressive study, interpretation, and codification of customary law, with a view to evolving in appropriate cases a unified system of rules of customary law. So that is one thing that you should keep in mind. And what are the functions of a traditional councils relating to customary law? Section 50 makes the point that where a traditional council determines that the customary law which is enforced within this area is uncertain or considers it desirable that it should be modified or assimilated by the common law, the council shall make representation on the matter to the House of Chiefs in the region. So if you look at it, the traditional councils, they're actually not living up to their full obligation imposed on them by the law. As far as our customary law is concerned, they're actually supposed to be studying aspect of customary law, and where we have a lack of certainty in certain areas, try and see how it can be developed, borrowing from the common law, tweaking it here and there, and so on, and then making suggestions to the regional House of Chiefs in that region. So that is one thing that we should keep in mind. So if you are doing anything about customary law, I think that it is useful to also have these provisions of the Chieftaincy Act, Act 759 also in mind. And again, declaration of customary law. If you look at section 51, a regional house may draft a declaration of what, in its opinion, is a customary law rule enforced in the region or any part of that region. after receiving representation from a traditional council or on its own initiative, is so requested in writing by the National House. So this is also very important. It's part of the efforts to also systematically compile and codify the customary law. So the regional house, after getting the necessary representation of the traditional council, can definitely make a pronouncement that this is the proper position of the customary law regarding this particular subject matter, and so on and so forth. So let's keep that in mind. And please look at the rest of the provisions on declaration of customary law per section 51. I see that some of you have your hand up. Okay. Yes, Chris.
Hello.
Yeah, I can hear you.
Okay. No. Thank you. In the definition of chiefs, we realize that queen mothers are part of them. So does it mean that queen mothers can equally be elected to serve on the National House of Chiefs Judicial Committee and that of the Regional House of Chiefs National Committee?
Okay, so if you look at that is a debate which has been going on for quite some time. I'd like you to also look at the Constitutional Review Commission, because if you look at the National House of Chiefs, composition is by the paramount chiefs. And the paramount chiefs, we're not talking about the paramount queen mothers as it were, but that is the concern which are going on, for which reason some of the queen mothers would like to be given equal status as the queen, and so on. So look at the Constitutional Review Commission report on that aspect of the debate. Nenebe. Yeah, Nenebe. Nenebe. Oh, it's gone. Nenebe. Okay, it doesn't. So please, before I leave, I would like you to pay attention to all the, let me emphasize. For customary law, I'd like you to pay attention to section 49, 50, 51, 52, 53, 54. These are very important. 55. These are very important provisions that we need to pay attention if we are going to do any meaningful write-up on customary law.
Doc, my question is that, good evening, Doc.
Yeah, good evening.
Doc, respectfully, my question is that, considering Article 2701, considering Article 2701, do you think that a commission of inquiry can be called upon to adjudicate chieftaincy matters?
2701. Oh.
Yes, please.
A commission of inquiry cannot.
I'm saying that putting Article 2701 in perspective, do you think that a commission of inquiry can be called upon to adjudicate a matter that concerns chieftaincy?
No, unless it's at the request of the particular no, it cannot. I know you are referring to the WACU, what do you call it, the commission and so on, isn't it?
Yes, sir. I was preparing on the commission of inquiry, and then I realized that I saw a case.
Before we discuss commission of inquiry, maybe I'll just have a short discussion that some of you said we should.
That's okay. That's okay. Then I'll reserve my further question.
All right.
For now.
Okay, so
all right. Thank you, Doc.
Thank you very much. And then,
Hello, Doc.
in tomorrow. Thank you very much.
Hello, Doc.
Yeah. Who is there? Yeah, mention your name. Chris?
Yes, Doc.
Yeah, Nenebe, yeah.
Doc, I'm trying to ask this. You know, if you read at the Constitution, Article 131 clause 4.
131 clause 4.
Clause 4, yes.
Okay.
Doc, it says that an appeal from a decision of the Judicial Committee of the National House of Chiefs shall lie to the Supreme Court with the leave of that Judicial Committee. If you read the Chieftaincy
Act, yeah.
It talks about when the appeal is coming from a case that has been decided on by the National House of Chiefs in its original jurisdiction capacity, then it has to be of right. I don't know if it is not in contravention with Article 131 clause 4.
Oh, I think that in my view, is not in contravention, because let's look at the two types of situations. A case started for the first time in the Judicial Committee of the National House of Chiefs. So that case is within the original jurisdiction of the National House of Chiefs, okay? The Judicial Committee of the National House of Chiefs has concluded the case and you are not satisfied with it. You want to appeal. You haven't had any opportunity. This is the first time you've had the opportunity of it being adjudicated in the original jurisdiction of the National House of Chiefs. So you can appeal automatically to the Supreme Court. You don't need leave. But let's look at the other way, where you litigated the matter at the Judicial Committee of the Original House of Chiefs, and you are not happy, you are not satisfied. So you appeal to the National House of Chiefs Judicial Committee in its appellate jurisdiction. You have had two opportunities in having the matter being adjudicated. So if you want to appeal to the Supreme Court, you need to show cause, you need to demonstrate why it is necessary for you to be allowed to appeal. And then you'll be given the permission or the leave, and then you appeal. So I think that what we have in Article 131, clause 4, if you take the literal reading of it, right, if you take the literal reading of it, then it may probably reinforce the position that the Act 759, the Chieftaincy Act, is trying to contravene the Constitution. But if you apply the purposive approach, if you apply the purposive approach to interpretation, I don't think that there's any inconsistency between Article 1314 and the Chieftaincy Act. I think, yeah. Okay, so thank you very much for coming, and then we'll meet again.